Well, good morning, everyone, and welcome back to AJ108 Criminal Investigation. My name is Tony Farrar, and of course, I am your instructor for the semester. This week's chapter lecture is going to cover Chapter 4, where we are going to look at searches and seizure. We'll talk a little bit about the Fourth Amendment as well. Now, there's a lot of content that we need to cover, so this will more than likely be a two-part lecture, as some other previous lectures have been as well. So let's go ahead and just jump right into this morning's lecture. So investigators conduct many types or different kinds of searches, and we know that searching is a vital task in most criminal investigations, because through searching, evidence of crime and against criminals is found. That's how you find it. So with that said, we need to keep in mind that every search must be firmly based on an understanding of the restrictions, meaning what you're allowed to do and also what you are not allowed to do. So the guidelines. So what is a search? A search is an examination of a person, place, or vehicle for contraband, illicit or stolen property, or some evidence of a crime to be used in prosecuting a criminal action or offense, and is, by its very nature, an intrusion into one's privacy. Because if you look at the Fourth Amendment, and we'll do that shortly, you'll see how these two things connect. So now that we know what a search is, what would be a seizure? So a seizure is a taking by law enforcement or other government agent of contraband evidence to a crime or even a person via arrest into custody. So that's a seizure. Now remember, I told you about the link between search and seizure in the Fourth Amendment. There was a case called United States versus Jacobson in 1984 where the Supreme Court actually defined a search as a governmental infringement of a legitimate expectation of privacy. So again, important for us to know. And it's applicable, as I said, in many different situations. And we're not going to dive into each one too deeply, but you can look at a vehicle search or the use of a canine or looking into somebody's garbage outside of the curtilage of their home. And we'll talk about that phrase a little bit later. Serving a search warrant. These are all different types. How about searching someone's home? Even with a warrant, can you look anywhere? The same with a vehicle. Are there any exceptions? Can you look over somebody's fence? Let's say from a neighbor's house. And in a public, let's say just in a stop based on reasonable suspicion, can I go through your belongings? So a lot of different things to consider. But consider the Fourth Amendment now, because the Fourth Amendment strikes a balance between individual liberties and the rights of society. And it is an outgrowth of the desire of the founders of the United States to eliminate the offensive British practices that existed before the Revolutionary War, such as things like forcing colonists to provide housing for the soldiers, or indiscriminately searching homes of those that were suspected of any type of disloyalty to the king. But the Fourth Amendment, this amendment is meant to ensure citizens' dignity and their privacy. So the courts are bound by rules and can admit evidence only if it is obtained constitutionally. And we'll talk about a couple of different aspects here in just a minute. So with that being said, again, we need to understand and keep in mind that the legality of a search must always be kept in mind. And that understanding of the Fourth Amendment and its relevance for searches and seizures is critical to not just any patrol officer, but especially to a seasoned investigator. And I have a link to if you want to watch a video on the Fourth Amendment, you could go there and you can watch that if you so desire. So the Fourth Amendment is basically broken up into two clauses of importance. Anybody have an idea? I mean, think about it for a second. It's got two parts to it, if you will. So the parts are going to be the reasonableness clause and the warrant clause. So the reasonableness clause talks about the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. So this is the reasonableness portion, the reasonableness clause. And then there is the warrant clause. And it goes like this: and no warrants shall issue, but upon probable cause, supported by oath or affirmation. And we'll talk more about that. And particularly describing the place to be searched and the persons or things to be seized. And while we'll cover some of that later, why do you think that there needs to be some particularity as it relates to a search warrant? And why do we need to have probable cause for a search warrant? And we'll talk a little bit more about that as well. So kind of keep that in your head as we go a little bit further. So let's talk then about this word reasonableness, what it kind of really means. So the touchstone, or the basis for comparison of the Fourth Amendment, is reasonableness. And you need to strike, again, that balance of an individual's privacy and the degree to work the case. So as said by, in the textbook, it gives this kind of analysis. The reasonableness of a search is determined by assessing, on one hand, the degree to which it intrudes upon a person's privacy, and on the other, the degree to which it is needed for the promotion of legitimate governmental interests, meaning following up on the case. So in short, the Fourth Amendment prohibits unreasonable searches and seizure, but it doesn't prohibit everything. But again, the basis is built on this word reasonableness. So what is reasonable or unreasonable? And this is something that we really need to know. Well, if you look it up, you get this. So let's look at reasonable. Having sound judgment, fair and sensible, based on good sense, and some synonyms that fall into play: sensible, rational, open to reason, logical, fair, practical, fitting, proper. And then if you look up unreasonable, you have the definition: not guided by or based on good sense, or beyond the limits of acceptability or fairness. So a couple of synonyms there would be unhelpful, troublesome, excessive, extreme, exaggerated. So you can see some of the dictionary definitions. But a lot of this really depends, this reasonableness word depends on a variety of considerations and circumstances. But simply stated, reasonable means sensible, rational, justifiable. And thus a key consideration in determining whether a search or seizure is in fact reasonable, again, goes back to what we've already said. It's the balance between individual rights and the needs of society. And I hope that kind of makes sense to everybody. So part of a lot of this is that we're going to be talking about as it relates to searching and seizure is going to be grounded, if you will, on this phrase that we're going to learn right now, this term called probable cause. Now, probable cause exists when facts and circumstances are sufficient enough in themselves to warrant a person of, and here's that word again, reasonable, and get used to it, you're going to hear this word again, so reasonable caution to believe that a crime has been or is being committed. So when it relates to a search, probable cause to search requires that a combination of facts make it more than likely than not that items sought are where the police believe them to be. Does that kind of make sense? And probable cause is a stronger burden, if you will, than reasonable suspicion. And if you haven't really looked at what we call burdens, you'll hear three that are quite prevalent. You'll hear reasonable suspicion, you'll hear probable cause, and then you'll also hear proof beyond a reasonable doubt, which is required for conviction. And so how do we've defined it, so let's kind of talk a little bit more to make it maybe easier to understand. So there's a case, Smith versus United States, that defines probable cause as follows, and maybe this kind of helps. The sum of layers of information and the combination of what the police have heard, what they know, and what they observed as trained officers. So it's kind of a totality of the circumstance type principle on which a number of legal assessments are made. So hopefully that kind of makes sense. And probable cause it's not like a mathematical formula. And the totality of circumstances also, it's not a mathematical formula for achieving a certain number of factors. Rather, it looks at what factors exist to assess whether the sum total would lead, again, a reasonable person to believe what the officers concluded. So again, hopefully, I know it's a lot of legalese stuff, but you know, we have to kind of learn it. So again, you know, this totality of circumstances, which is how they kind of look at probable cause, it's not based on some very strict formula. And as you know, probable cause must be established before a lawful search or arrest can be made, and we'll learn more about the burdens in a minute. But it is also important to note that terms used here are arrest and search, not stop and frisk. Now, and we'll talk more about stop and frisk. Facts and evidence obtained after a search or arrest cannot be used to establish probable cause because you obtain those after. Does that kind of make sense? They can be used, however, to maybe strengthen your case. But let's look at kind of a list of what would build upon probable cause. Because we've defined it, we've talked about how we kind of look at it or how it's addressed in that totality of circumstances. But now let's kind of look at it from, well, how do you develop it? Well, a partial list of factors to build probable cause include things like flight or furtive movements or hiding, an attempt to destroy evidence, resisting police officers, evasive answers, being in possession of contraband, having a criminal record, the officer or investigator's training and experience, somebody's suspicious behavior, and information from informants. So these are all conditions that will help you build upon probable cause. And the more of these conditions that exist, the stronger your level of probable cause is. So again, hopefully that makes sense as well. Okay, so I talked a little bit about burdens of proof. So here's an example, and we're not going to look at each one of these because we don't have time, but we're going to look at what I call the big three. So the first at the top, this is beyond a reasonable doubt, and this is what you need. This is what a court needs to convict an individual, and it basically requires the elimination of doubt. So it's beyond a reasonable doubt, and the reason that the burden is so high is because that you're talking about somebody's freedom at stake. So you want to make that burden extremely high. And then you have a couple of other ones. You have clear and convincing evidence and preponderance, but we're going to drop down to these two. Probable cause, right here, talks about facts and circumstances that lead that ordinary person to believe. So remember, like that list of factors we talked about that might lead an ordinary person to believe that somebody is involved in criminal activity or is about to commit a crime, etc. You need probable cause to search or to arrest, typically. And then at the very bottom, you have reasonable suspicion. Now, a lot of times these two are kind of misinterpreted. Reasonable suspicion is where a police officer or investigator is able to articulate specific facts to where they believe that somebody is or is about to be involved in some type of criminal activity. And reasonable suspicion allows you to stop and investigate. But that doesn't mean you can search. You need to have the burden higher to reach probable cause to search or to seize. So hopefully that kind of makes sense. Now, there's always a little exception built in, and we'll talk about that in just a few minutes. But these are burdens of proof. And if you've never seen a probable cause summary form, and I throw this in there because we're just finishing up with probable cause, this is a form that an officer would fill out, basically establishing facts and elements of the defendant, and they send this over to the, let's say, the county jail with the defendant to determine whether the person is going to be held or released pending hearing, etc. But this is what they call a probable cause declaration, because again, you need that. All right, so now that we've talked a little bit about things that are leading up to, let's say, a search, let's talk a little bit about legal searches. So because an investigative search is an intrusion into someone's privacy, it is, in fact, strictly regulated by the Fourth Amendment to the Constitution. We know that. However, when there is no reasonable expectation of privacy, there exists no search to justify, and so no warrant is needed. So sometimes I always ask this question: do police always need a warrant to search for evidence? And the answer is going to be no, they don't always need a warrant, because if we needed a warrant every time, let's say we contact someone in the street, we have probable cause to search because we believe they're armed, but we can't stop what's already in motion and call time out and get a warrant. Does that kind of make sense? So again, you don't need a warrant every single time. Now, the reasonable expectation of privacy implied in the Fourth Amendment was first explained by the Supreme Court in a case called Katz versus United States, and that's Katz spelled K-A-T-Z, when it held that a person knowingly exposes to the public, even in his own home or office, is not subject of Fourth Amendment protection. But what he seeks to preserve as private, even in an area accessible to the public, may be constitutionally protected. Thus, any action by the government that violates a person's reasonable expectation of privacy then would be considered a search. But there are exceptions, and the courts have adopted guidelines to kind of assure law enforcement personnel that if they adhere to certain rules, their searches or seizures will then be reasonable and thus legal. So a search, again, can be justified and therefore considered legal in any of the following, and we're going to kind of take a quick look at some of these. A search warrant. So if we get a search warrant, it's legal to search. Consent, and we'll talk more about consent. An officer stops a suspicious person and believes the person may be armed, and this is based on a case called Terry versus Ohio. It's called a Terry stop or stop and frisk, and we'll talk a little bit about that in just a few minutes. But I put it in bold because I want you to remember that, because this is one little exception when it comes to searching. But let's look at the rest of these. So search is incidental to a lawful arrest, meaning after you're placed into custody, a police officer can search you. There is some type of an emergency or an emergency circumstance. For inventory purposes, at border crossings, involving an officer using their plain senses like sight, sound, smell, or touch, and where the search might involve open fields or abandoned property or a public place where there is no reasonable expectation of privacy. So if any one of these preconditions exist, a search will be considered reasonable and therefore legal. Now, keep in mind that some states are different. We've talked about this. So states can impose other restrictions on police powers within their particular boundaries as well. But typically, all of the searches that we talked about, these would all be justified. Okay, so now we want to talk about a search with a warrant. So technically, according to the Fourth Amendment, all searches are to be conducted under the authority of a warrant. In 1948, the Supreme Court ruled in a case called Johnson versus United States that without emergency circumstances, searches are presumptively unconstitutional if not authorized by a search warrant. Now, that later changed with a couple of different cases that came along and some exceptions. Because again, we know that you can't always get a search warrant. Look at some of the situations or considerations that we just went through. An emergency. Let's say smoke's coming out of a house. Do you have time to get a search warrant to go in and save somebody? I mean, what if somebody needs medical attention? What if you believe somebody is being hurt badly inside of a home? So there are exceptions. So let's kind of continue on. To obtain a valid search warrant, officers must appear before a judge and establish probable cause because they're going to want to search. Just like we would want to search somebody in the field, we would need probable cause if we didn't have a warrant. We're going to need probable cause to have the judge issue the warrant. Hopefully that makes sense. So to get a warrant, you appear before a judge and establish probable cause to believe that the location that you want to enter contains evidence of a crime, and the warrant's going to specifically describe the evidence that you're looking for. And there's a reason for having to describe that, and we'll talk about that. A search warrant must be limited to the specific area and specific items named in the warrant, and this is called the particularity requirement, and it's based on a case called Stanford versus Texas. And it's important to know because during a search conducted with a warrant, items not specified in the warrant may be seized if they are similar to the items described, if they are related to the particular crime described, if they are contraband, or if such unrelated, unspecified evidence is in plain view. And I know that's a lot of legalese, and we're going to kind of get into this a little bit more. But the reason for describing the items in the warrant is so law enforcement doesn't fish for something. I'll give you a very quick example. Let's say we're writing a warrant for stolen television sets, and the size of these TVs, they're big 50-inch screens. Would it be feasible for me to look in a small container on the counter for a 50-inch TV? The answer would be no. So that's the rationale for why they want you to describe what you're looking for. Now, if you find other illegal items as you're looking for these, under certain circumstances, you can seize those items. So you don't have to turn your head to other illegal items of contraband. But hopefully that kind of explains that particularity requirement. And then there's a couple of other interesting things that we need to note as it relates to a search warrant. The first is what they call night service. So night service, or in your textbook they call it night capped. I've never heard it that way. We call it night service, but either way it means the same thing. But a night service warrant authorizes a search or arrest at any time, day or night. Night service warrants can be generally can be served when a suspect is in any public area, regardless of time. And the court determines the legitimacy of a night service warrant based on considerations such as safety of the public and those executing the warrants, the prevention or loss of evidence or destruction of evidence, or even removal of evidence. So that's one aspect to a warrant. Another aspect would be what we call knock notice. So usually the officer serving the warrant knocks on the door of the location, states the purpose of the search, and gives a copy of the warrant to the person who has answered the knock. Now, this procedure follows the knock notice rule, which is based on English common law and ensures the right to privacy in somebody's house. And that makes sense. The knock notice rule requires officers serving a search warrant to knock and announce themselves and then wait, and you're going to love it, here it is again, a reasonable length of time, remember I told you you'd hear that again, before attempting entry. So there's a lot of questions now. Okay, well, now what is reasonable? Well, if it's an apartment that's a one-bedroom, reasonable wouldn't be that much time. If it's some big estate, 10-bedroom estate somewhere, you would want to give them a little bit more time. So in a case called Wilson versus Arkansas, the court made this century-old rule a constitutional mandate, stating that the underlying command of the Fourth Amendment is always that searches and seizures be reasonable, and that the common law requirement that officers announce their identity and purpose before entering a house forms part of the Fourth Amendment inquiry into the reasonableness of the officer's entry. So the knock and notice rule is intended to, 1, protect citizens' right to privacy, 2, reduce the risk of possible violence to police and occupants, and 3, to prevent needless destruction of private property, meaning crushing in somebody's door. Now, most officers find it judicious to know and announce their presence and intentions. Now, there is something called a surprise entry or a no-knock. And the courts have also recognized that in some instances, a safe and effective entry into a home is going to require an exception to the knock notice rule. And this would be what we would call a no-knock warrant. So a no-knock warrant may be issued if evidence may be easily destroyed, or if there is advanced knowledge of, let's say, danger to the officers by way of weapons or explosives, etc. And that would mean that you don't have to give the knock notice. You don't have to knock on the door and say something like, Rialto Police Department, search warrant, demand entry. And that's typically what you will hear, because you don't have to state your name, but you state your agency. And you tell them why they're there, search warrant, and that you want to come inside. You're demanding entry. And then you would give people reasonable time to come to the door. And we've kind of talked about that reasonable thing. In a no-knock warrant, you don't have to do that. And then finally, there's another little kind of weird thing built into warrants. And it's called anticipatory search warrants. So in a case called United States versus Grubbs, the Supreme Court approved the use of an anticipatory search warrant, and it's kind of different. You may have heard, it may also be referred to as a sneak and peek. So the court defined an anticipatory warrant as one based upon an affidavit showing probable cause, so you still have to show that at some future time, but not presently, certain evidence of a crime will be located at a specific place. So interesting, isn't it? So the court noted that, in a sense, all search warrants are anticipatory. Anticipatory warrants are constitutional if a proper showing is made that contraband or evidence will likely be found at the target location at a given time, or when a specific triggering event occurs. So again, kind of an interesting thing, this anticipatory type search warrant. Okay, so that's a little bit about search warrants. And if you've never seen a search warrant, here is what a search warrant looks like. On the left, you would have the face page, and you've heard the word affidavit before, and here's would be items that you're looking for, whether it's stolen property, things committed in a felony, etc., and a place for you to sign. And then here would be places to be searched. And remember, in a search warrant, especially, not just the items, you have to be particular in that, but the place, that particularity requirement also makes you describe the location. So I know it's tough to see, but if you look here, this officer describes the residence as a single-story, single-family apartment located on the top floor of a two-story complex, off-white stucco exterior with white trim and a red. So you see how particular it is? Because he wants he wants them to know that I'm going to this very specific place, and I'm even going to describe it, and I'm even going to describe the persons to be searched. So hopefully that kind of makes sense. And the same with vehicles. And then if we look at the other part of the warrant, the evidence, very particular. Any firearms, cleanings, just everything is listed here. So the court knows exactly what the officer is looking for. And then we talked about probable cause. I didn't put in the whole declaration, but here is the officer's probable cause. And even here, any off-site searches, meaning like a shed or a car parked in the driveway, or things like that, or computers. But here's the probable cause declaration, and this is the redacted stuff. So it's just stuff that you can't see because this is an actual warrant. All right, so with that said, now let's kind of talk a little bit about consent. And this is always it's a great tool for law enforcement, but it's always can be a little contentious, and there's always a challenge sometimes. So officers can conduct a search without a warrant under certain circumstances. We know that, and one of those would be when consent is given to search. And as with a search warrant, searches conducted with consent have limitations. One of the big limitations is that the consent has to be given freely and voluntary. But again, first, officers must convey a genuine request for permission to search, not simply state that they would like to conduct a search and then just kind of like do it. Then consent to search must be given freely and voluntarily, and not in response to an officer's claim of lawful authority or a request phrased as a command or a threat. So it can't be, if you don't let me search, this is going to happen, because that's coercive. It needs to be voluntary, truly voluntary. So a genuine affirmative reply must also be given. A simple nodding of the head or opening of a door is not sufficient, and silence is not consent. So you can see that there are a lot of technicalities built in here. The Supreme Court ruled in a case called Schlecknoth versus Bustamante that it would use the totality of circumstance test, we've heard that already, to determine whether consent was voluntary. And this includes the characteristics of the subject, the environment, the location, the number of people, the number of officers present, and time of day, the subject's actions or statements, and the officer's actions or statements. Even when police have an alternative justification for a search, such as a warrant, they can still ask for consent to establish another layer of validation for their actions. And they may ask for this consent even if the subject is in custody and is in handcuffs, or has been stopped for a minor traffic violation and is not free to go. So officers can ask for consent. Even after you've been taken into custody, they can ask for consent. Now, the person does not have to consent, though, okay? So just understand that. So officers should thoroughly document everything they say and do when asking for consent and while conducting the search. Now, some departments use a prepared consent to search form to be signed by the person giving consent, and this is good. Some departments have body cameras, and they'll have the camera rolling when they ask for consent. That's great as well. The person, though, has the right to limit the area for which consent is given, and furthermore, the person may revoke the consent at any time during the search, and if this happens, the officers are obligated to stop. So again, a person can say, you can search this area and this area, but not that area. It can be that descriptive. Or they can say, search whatever you want, and you're halfway through and they say, nah, I think you're done. I don't want you to search anymore. And you would have to stop. So a lot of information, and it's very important that officers understand the issues surrounding consent to search. And there's a couple of different case laws that talk about search with consent. One is United States versus Matlock, another is Illinois versus Rodriguez, and then we just talked about the Schneckloth versus Bustamante case. So these are all cases that deal specifically with that. And then if you've never seen what a consent to search form looks like, here's a template or an example of what a form would actually look like. Now, even if they sign the consent to search form and you start searching, if they want to stop it, they can still stop the search. You can't just say, well, you signed the form, so too bad. Does that make sense? So you have to understand that there are parameters as it relates to a search. Okay, so now we're gonna continue with searches, but we're gonna talk about one very controversial topic, and that is what we call a stop and frisk. It's also known as a pat down. So another exception to the warrant requirement is what we call a stop and frisk situation. Now, two situations require police officers to stop and question individuals. One, to investigate suspicious circumstances, and remember, you have to be able to articulate those. And two, to identify someone who looks like a suspect named in an arrest warrant or like an all points bulletin or something similar. So there's a couple of situations where officers can stop someone. Now, you can also do something called a consensual contact. We're not going to talk too much about that, where you ask if you can speak to someone. But keep in mind, you're not detaining them. They're free to go right away. This type of situation is where you're going to stop someone and question them because you believe that something is happening. So the procedure for stopping and questioning suspects are regulated by the same justifications and limitations associated with lawful searches and seizures. If it is suspected that a person stopped for questioning may be armed, the officer is justified in conducting what we call a pat-down for weapons. And this is kind of the interesting part, okay? So again, the prime requisite for stopping, questioning, and possibly frisking someone is going to be this reasonable suspicion, okay? It's a lesser standard than probable cause, but it's kind of difficult to define. So this is kind of the one exception, because a pat-down is technically a search. And I know a few minutes ago I said you need in order to search, you need one of these exceptions we've talked about, emergency, blah, 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 or, consent or different things. Well, if you stop someone and you have reasonable suspicion to stop them, and you have reasonable suspicion to believe that they are armed, you can conduct a pat-down of their outer clothing, which is technically a search, but it's still reasonable within the scope of what we're talking about. And the case that we're talking about is Terry versus Ohio. So again, the prime requisite for stopping, questioning, and possibly frisking someone is reasonable suspicion. We know it's a lesser standard than probable cause. A stop and frisk has two separate actions, and each must be separately justified. Just because a stop is permissible doesn't mean a frisk is permissible. Does that kind of make sense to everybody? So we might have reasonable suspicion to stop you and investigate something, but that doesn't give us enough to pat you down unless we believe that you're armed, that we are reasonably we have that suspicion that you're armed. Does that kind of make sense? So again, a stop and frisk, there's two separate actions, and each must be separately justified. So again, just because a stop is permissible doesn't mean a frisk is permissible. In fact, in most stops, a non-consensual frisk would not be permitted because of the absence of reasonable suspicion of the presence of weapons. Now, the landmark decision in Terry versus Ohio, this was a 1968 case, established the police officer's right to pat down or frisk a person that they have stopped to question if they believe the person might be armed or dangerous. So I hope that clears it up. Now, I have a couple of video clips on stop and frisk that you can look at if you like. Again, remember that a pat down, you can pat someone down for weapons if you meet both of the criteria. But just because an officer has enough reasonable suspicion to stop you doesn't automatically justify that search or the frisk. Okay? All right, so I know it's a little bit technical, a little bit difficult, but I'm pretty sure that you got it. And then one last kind of thing on that. The courts also warned, and we're still kind of backing up a little bit talking about stop and frisk, that a pat down or frisk is a serious intrusion upon the sanctity of the person, which may inflict great indignity and arouse strong resentment, and it is not to be undertaken lightly. The search in a frisk is sometimes referred to as a safety search. Officers should definitely know the limits of their authority to protect themselves, both physically and legally so that they're never forced to choose between being safe and being wrong, or possibly even being sued. So again, the Terry decision established that a pat down or a frisk is a kind of a protective search for weapons, if you will, and as such must be confined to that to a scope reasonably designed to discover things like guns or knives or other types of weapons, etc. So, okay, so enough on stop and frisk. So now another search would be search incident to an arrest. So every lawful arrest is accompanied by a search of the arrested person to protect the arresting officers and others, and to prevent destruction of evidence. Because I've seen many times where someone was brought into, let's say, our jail cell, in a holding cell, and an officer would put them in there and they failed to search, and you would come into the cell and on the ground in the corner would be a handgun. Isn't that scary? I mean, yeah, don't even think about that. It's just brutally scary, but it's true. So the courts have given us this right that it's lawful after you've been taken into custody that you can, law enforcement can do a search incident to arrest. And this search, unlike the kind of, outer clothing type search, involves going through your pockets, your purses, your bags, your wallets, any weapon, dangerous substance, or evidence discovered in the search is going to be legal. So if I arrest you for something else and I'm going through your pockets, let's say I even arrest you on a warrant for your arrest, and you're at the jail and you're in the booking area, and I go through your pockets and I find some drugs. Those drugs are found legally because they're found during a search incident to a lawful arrest. Now, keep in mind also, and we'll talk a little bit about shortly, some items, such as locked containers or cell phones, may be temporarily seized while a warrant is sought, because there are some limitations on a search incidental to an arrest, and we're going to talk about one right now. The pretty famous case is called Schimmel versus California, and I have a video there that if you want to take a look at it, you can. But let's talk about it. So the Schimmel decision established that a search incidental to a lawful arrest must be made simultaneously with the arrest and must be confined to the area within the suspect's immediate control. And you're probably thinking, well, what does that mean? Well, we're going to kind of take a look at that. So a person's immediate control encompasses the area within a person's reach. And in this case, the court noted that using an arrest to justify a thorough search would give police the power to conduct general searches, which means just go around the house and search for anything. And those were declared unconstitutional like 200 years ago. So, I have a little diagram up here. And let's just say that we're arresting this suspect right here. And if we were to arrest him here, and let's say that this is his living room, we're kind of going to look at places that we can search. So remember what it said, immediate control. So is the couch within immediate control? It probably is. Even the top of the table, the little nightstand, the little drawer right here. But things that are further away, way over here, that's really not in immediate control. Because again, it's supposed to be for protection. Now, one other interesting thing, and we'll talk about it a little bit later, that if we do make an arrest, let's say in someone's home, if we have reason to believe that there are other individuals that could cause us harm, we could do a sweep, which means that we could walk through the house quickly, not searching in all these places, but making sure nobody's hiding, and then come back out and deal with our arrested suspect. So we could do a protective sweep, but you can't search. You can only search. Now, could you get a warrant to search the rest? Yes, you could. Could you ask him for consent? Yes, you could. So there's other things that you could do, but you have to make sure that you understand the dynamics. But the Chamel case said that we can search incident to a lawful arrest within that immediate control area. So hopefully that photo there kind of helped. And I talked about it a second ago, that there was a case, Maryland versus Bowie, and this was about 1990, expanded the area of a premise search following a lawful arrest to ensure officer safety. Now, in this case, the Supreme Court added authority for the police to search the areas immediately adjoining the place of arrest. And this type of protective sweep, or they call it a Bowie sweep for short because it's named after the case law, is justified when reasonable suspicion exists, there's that word again, that another person might be present who might pose a danger to the arresting officers. And again, the search has to be confined to the areas where somebody might be hiding, not in a dresser drawer where nobody can fit. So hopefully that makes sense as well. But this is a Bowie sweep, and it relates again to a search incident to a lawful arrest. All right. So another circumstance where you can search would be an emergency. And the word, I have a really big problem saying the word exigent. See, that's really tough. Some people can say it, I can't. I like emergency, so I'm not perfect. Well, anyway, so in situations where police officers believe there is probable cause, but have no time to secure a warrant, shots fired in a house, people screaming, they may act on their own discretion. And this really does, require some imminent danger to public safety or medical emergencies. These are situations that are classified as these emergency circumstances. And most courts recognize certain conditions that must be met to support a warrantless entry under these emergency circumstances, this type of exception. Example, officers must believe a real emergency exists requiring immediate action to protect or preserve life or prevent serious injury. And also the emergency and the area entered or searched must have a connection. You can't just run. They have to be connected. In a case called Mincy versus Arizona, the Supreme Court stated that the Fourth Amendment does not require police officers to delay a search during an investigation if to do so would gravely endanger their lives or the lives of others. Now, once the danger has been eliminated, any further search should be conducted only after obtaining a warrant. So that makes sense. So if you look here, and whether or not, again, if you truly believe that this house is on fire, and some of these are at a different level, so this is pretty simple. You don't have time to get a search warrant for these places to run in and try to save somebody. This is a lot of smoke. Same thing. Now, if you think, well, I wonder if, someone's just frying up some food or something, and but if you truly believe that someone is in imminent danger, you have the right to go in and to check that location. Now, that doesn't mean search in all the drawers. It means to find the danger, okay, to save the person, to preserve that life or to prevent injury. And after that's gone, you need to get a search warrant if you want to do anything more. So that would be an emergency thing. So again, conditions must be met under these emergency circumstances. You have to believe there's a real emergency that requires immediate action. I have to do this now. And the emergency and area search, they have to be connected. So it has to. You can't just go into some place that's not connected with the emergency. That doesn't make sense. Okay, so what about vehicles? And it gets a little tough here when we start talking about vehicles. There's a lot of A lot of controversy built into searching, but vehicles as well. So a vehicle stop is a seizure within the meaning of the Fourth Amendment, and therefore must generally be supported by reasonable suspicion. So don't get these things kind of mixed up. So pulling someone over for a traffic violation, that's not probable cause. It's reasonable suspicion. I have reasonable suspicion to believe that you violated the I didn't stop for a red light law. I was the speeding law. Does that make sense? Probable cause is a higher burden. So all you to stop someone, to detain them, is just you need to support it by reasonable suspicion. Now, vehicles, because of their mobility, the fact that they can be easily and quickly moved before a warrant can be obtained, a vehicle may need to be searched without a warrant. And they are, vehicles are mobile. So there's going to be maybe not quite the tough burden as in other places. So the justified warrantless search of a movable vehicle is known as the automobile exception. The precedent case for which this was established was a case called Carroll versus United States. And this, it's an old case, and it's kind of held true today. The Carroll decision established that automobiles may be searched without a warrant. One, if there is probable cause to search, right? You still need probable cause. And two, the vehicle would be gone before a search warrant could be obtained. Now, there's a lot of other cases that kind of come into play, but this is just kind of an overview. So that's the Carroll decision. That's Carroll versus United States, 1925. Well, now I want to talk about one last. Well, there's lots of things that sometimes create controversy, but I want to talk to you about what is known as a pretext stop. Again, and we're still talking about warrantless searches of vehicles. So a pretext stop occurs when officers stop a vehicle for a relatively minor offense, when in actuality their real motivation is to search for evidence of a more serious crime. And the case that covers this is called Wren versus United States. And in this case, plainclothes officers saw a truck wait at a stop sign for an unusually long period of time. It turned suddenly without signaling and then sped away. And the officers pursued and stopped the vehicle. And as they approached the truck, they saw the driver, Wren, holding bags of crack cocaine, and they arrested him on federal drug charges. And when argued that the police used the traffic stop as a pretext to uncover the drugs, or that was the argument, but the court here held that as long as probable cause existed to believe a traffic violation occurred, stopping the motor vehicle, it was reasonable. So kind of what they're saying is that the intention of the officers, or the subjective intentions, play no role in ordinary probable cause Fourth Amendment analysis. So what that means in regular terms that we can hopefully all understand, because I know that's a lot of like legalese, an officer's ulterior motive for stopping a vehicle is not unconstitutional as long as legal justification exists for the valid stop. In other words, any pretext is overridden by an officer's cause to believe the motorist is or about to be engaged in criminal activity. So you can kind of like push that all the way down and summarize it and say that even if my motivation is to get into your car and search because I know that you're the local drug dealer, as long as I stop you, I have reasonable suspicion to stop you, and it's for a lawful reason, that being the traffic violation, then the stop is good. And while I'm investigating, if the level burden rises to probable cause and I believe that there's, say, drugs somewhere, then it's all good. Does that kind of make sense? But that's the issues surrounding what is known as a pretext stop. Okay, so we have a lot of other little pieces to cover as it relates to searches, but we're right about the 60-minute mark, just a touch over. So we're going to stop here. And when we come back, we're going to pick up with some more legal searches, of course, but we're going to talk about inventory searches. So this will conclude part 1 of chapter 4.